In other news today, the suspended public protector, Advocate Busisiwe Mkhwebane, is challenging her suspension by President Ramaphosa in court. Her lawyers say the letter sent by the parliamentary speaker, Nosiviwe Mapisa-Nqakula, to President Cryil Ramaphosa, which led to her being suspended, should be declared null and void. In March, Mapisa-Nqakula wrote to the President telling him that the Section 194 committee would now begin its work looking into Mkhwebane's fitness to hold office. Our reporter, Athi Mtongana, has been following the court action today. She joins us. Athi, what's the latest?
Well, much of what was actually argued today, especially on the side of Advocate Busisiwe Mkhwebane by Advocate Athi Mtongana, is much of what has already been deliberated in the Section 194 inquiry before Parliament. And so what he's essentially saying, Stephen, is that the suspension by President Cryil Ramaphosa was done prematurely and that he actually did not choose to wait for the pending outcome of the Western Cape High Court pertaining to a judgment that would have come out insofar as the interim relief regarding the interdict for the Section 194 committee, as well as the pending suspension at the time, because he hadn't suspended her at the time when they were waiting for the outcome from the Western Cape High Court. And so it's on those bases and on those merits that Advocate Athi Mtongana is arguing before the three justices before them in these 2 days, which this particular case is seen to be going to be heard. He was basically saying that the letter as well that was sent by the Speaker of the National Assembly to the President triggered the suspension, and they are saying that the President should have taken time to actually get advice before just moving based just on that letter that was sent by the Speaker of the National Assembly. And then he also put forward the issue of the CR17 campaign, the fact that some of the charges, the 4 charges before the Public Protector in the Section 194 inquiry in Parliament, are charges that are linking her work that she did when she was investigating the CR17 campaign funding. And they also raised the issue of the Phala Phala farm investigation that is currently taking place in the office of the Public Protector, where they were saying there, not only did the President suspend the Public Protector after asking those questions, those 31 questions to the President, but also the issue of the Phala Phala farm robbery insofar as the response of the President. Then they say that they want those answers that the President has given now to the office of the Public Protector to be given to them, given the fact that it is their client, Advocate Mkhwebane, who actually then went to compile those questions regarding the Phala Phala farm robbery investigation. And they're also going to be arguing as further as to say that these answers should also be made public, so that members of the public can also be aware of what actually happened during that robbery in Limpopo, saying it's a matter of public interest. We're going to be hearing a reply tomorrow from Advocate Athi Mtongana, but we also heard, of course, from Advocate Andrew Breitenbach on behalf of the National Assembly Speaker, Nosiviwe Mapisa-Nqakula, where he was raising interesting points which speak to him basically dismissing everything that has been presented by Advocate Athi Mtongana, saying it's a repetition of what we actually saw in Part A of their application here at the Western Cape High Court, because what they're doing now is essentially dealing with Part B of the application by Advocate Busisiwe Mkhwebane. And he also made mention of an issue pertaining to the letter which Advocate Mbofu also made mention of. Advocate Breitenbach saying that the letter was in fact factual and that the head of a legislature does have the right to write to the President. Otherwise, how else would the President know what is actually happening in the legislature? And that is pertaining to Parliament, and then it's moving to commence with the Section 194 inquiry. Another argument that Advocate Mbofu is bringing before the courts is the date of the commencing of these inquiry hearings in Parliament, saying that no one, including members of the application or the people in this particular court case, the parties that are involved, none of them actually are clear as to when the proceedings actually started in Parliament, because he's arguing, Advocate Dalimpofu that is, he's arguing that the President shouldn't have suspended the public protector when the hearings had not actually commenced. And then there was another issue that was raised by the justices to Advocate Dalimpofu, saying that it's interesting that he's raising the issue of the extension that the President was given in replying to the 31 questions. It's an issue that they also were confronted with when the public protector was asked by the President to respond and give him reasons why he shouldn't suspend her, and also the reply that was needed from the public protector when she was asked by the inquiry in Parliament to respond to written questions. She asked for extensions there, and the justices are saying if the public protector is finding an issue with the President being given an extension to respond to the 31 questions, it's interesting because they also were given extensions when they had to reply to written questions, or to written questions, yes, to the inquiry that's currently taking place in Parliament. So tomorrow we will then hear a reply from Advocate Dalimpofu when we resume at 9:30.
Athi Mtongana for that update. Thank you very much indeed. Do appreciate it.